As you probably know, I'm the leader basically of the panel, and everyone that are invited to this panel are invited by me, and I'm grateful that you managed to come, because some of the participants, including the one from the European Labour Authority, due to some natural disaster and weather conditions, couldn't come to the panel. But still, I hope that we will manage to cover all the topics that we wanted to. The whole aim of this panel was to cover the topics of posting of workers. That is not the quantitatively very interesting topic, but qualitatively it's very important. So I hope that we will manage to cover it from different perspectives, because I saw that a lot of you are going to talk about different sides of the posting of workers. Me personally, I'm going to give the general overview of the posting of workers in the European Union, but I'm going to focus on the subcontracting of posted workers within the European labor market. Professor Konjević already introduced me, so I'm going to skip that part, but I'm just going to start with the general overview. What are the posted workers? How is it functioning? And how are they determined in the European legislation? When it comes to the definition, who is actually a posted worker, you probably already know that posted workers are incorporated into the temporary labor mobility, and they are not considered as part of the Article 45 of the freedom of movement of workers. So they are not actually mobile workers, but they are service providers. It is not regulated by the European legislator, but it was determined by the Court of Justice of the European Union in the case law court called Ras Portuguesa. You probably have heard about it, because Ras Portuguesa was one of the crucial points in which posted workers were determined as the ones that are not incorporated into the host member state's labor market. Because of which Court of Justice said that they can't be considered as part of the freedom of movement, but as a part of freedom to provide services, because they are not integrating into the labor market enough of the host member state. That is quite not true, because let's picture, for example, the Finnish construction site. If we have for 12 months, let's say 4,000 workers in one construction site, and the question is if they are not actually influencing the labor market of that Finnish labor market or not. But that is a completely different discussion, and that discussion led to the Posted Workers Directive from 1996. That directive, as you probably already know, is the first one that determined the working conditions of the posted workers in the EU labor market. And after that, we had the huge enlargement of the European Union, even with the EU8 or EU2 countries. And we had a huge amount of posted workers on the EU labor market that wasn't expected before the enlargement. So enlargement was a crucial point from which we had to figure out how to deal with that amount of posted workers, especially since they weren't under the temporary arrangements. So the restrictions for the posted workers wasn't applied, which meant consequently that EU employers were using posted workers to basically avoid those restrictions that were applied for the freedom of movement of workers. And then, because of that enlargement and because of the huge amount of Central and Eastern European countries, workers entering into the labor market, we had a social dumping. It just started, and then from then, posting of workers was completely connected with the social dumping, and it became basically a synonym for it. As you probably know, social dumping is misusing the differences between wages and social contributions in different countries. And after the social dumping discussion, the whole fraudulent practices started in the sphere of posting of workers, because the employers, as I already said, started misusing the posting of workers in the fraudulent way, including in the subcontracting chains, which I'm going to talk about much more, because that is a topic of my PhD. In that case, we had the enforcement directive from 2014, which said that which regulated fraudulent practices in the scope of the posting of workers, including only one article related to the subcontracting chains, which regulated the liability of contractors in subcontracting chains. But I'm going to explain it a little bit later. So when we are talking about the subcontracting of posted workers, in my PhD research, I'm dealing with it as an abusive business model. So I'm not dealing with subcontracting. It is really a good practice for spreading the job between different employers. But when it comes to the posting of workers in the subcontracting chains, then it becomes a crucial issue, because then we have bad working conditions, extended working hours, substandard wages, increased level of work intensity, job instability, and so on. And beside all, we also have social dumping. So the reason why I'm going to talk about the subcontracting of posted workers is because posted workers are considered as a precarious workers in that sphere. And when it comes to the subcontracting, it is, as I already said, it is not automatically considered as a precarious or as an abusive business model, but in most of the cases, it can lead to exploitation of posted workers at the end of the chain, because it's very hard to track how are the posted workers treated in the whole subcontracting chain. But I'm going to explain how to prevent exploitation of posted workers in subcontracting chains. A lot of scholars were dealing with different mechanisms how to safeguard the rights of posted workers in subcontracting chains. I chose two of them. My hypothesis was that full chain liability and human rights due diligence are the most effective mechanisms to prevent social dumping of posted workers and to prevent exploitation of posted workers in subcontracting chains. First, I'm going to talk about the full chain liability. Full chain liability, I'm going to explain how it functions, because it can be a little bit complicated to understand. So if we have a subcontracting chain, at the end of the chain usually are the posted workers. When we talk about the types of liability in the subcontracting chains, we have two of them. We have joint and several liability, which means that the employer and the contractor of whom the employer is a direct subcontractor can be considered liable. And that is regulated by the Enforcement Directive from 2014. Enforcement Directive chose that kind of liability, even though that the trade unions said that chain liability is much more effective. And even though that Germany applied chain liability a long time ago. So the Enforcement Directive basically said that member states can choose either to apply obligatory joint and several liability, but they can choose to apply stricter rules. So they can choose to apply chain liability, and they can choose to apply the joint and several liability on more sectors than the construction sector. So the Enforcement Directive made two mistakes. They gave the option to choose the less strict rules, and they only provided it for construction sector. What happened in the end? Most of the countries chose the minimum level of protection, which means that they chose the joint and several liability only for the construction sector. I'm going to explain why Germany did a very good thing with expanding it to a chain liability, and how would it help to posted workers. When we are talking about the chain liability, we can talk about the full chain liability or the plain chain liability. The chain liability would mean that not only the employer and the contractor of whom the employer is a direct contractor can be considered liable, but basically the liability can be held up to the top of the chain, which means that even the principal and the first contractor can be considered liable for example, not paying the wages for the posted workers, for bad working conditions, for the exploitation of posted workers, for social contributions for the posted workers. So everything is connected with the whole chain, which means why would the chain liability be better than the joint and several liability? Because in that case, all the contractors or all the subjects of the subcontracting chain would be much more careful with which contractors are they going to cooperate. They wouldn't choose just random ones and just hoped for the best, but then they would be choosing the best ones, or the ones that are diligent to work with, not to be considered liable. So that is that preventive mechanism in safeguarding the posted workers in subcontracting chains. So when it comes to the best practices, I will talk about the report from the Council from April this year. But here is the picture how it looks actually the subcontracting chain. So you can understand how would the full chain liability function in the practice. So we would basically have all the parts of the subcontracting chain held liable or potentially held liable for the misusage of the rights of posted workers, not only the employer or the contractor in the end of the chain. Which means that if someone doesn't get the wage, they can claim the liability not only for one contractor or the employer, but also to the whole chain. So when it comes to the report of the application of the latest Posted Workers Directive from 2018, that directive, first of all, didn't do basically anything about the subcontracting chains. Enforcement directive is still reminding as the only proper legislation that is covering posted workers in subcontracting chains. There was one proposal from the Council when the Posted Workers Directive from 2018 was in the process. They proposed that maybe the best solution would be if they would make obligatory the member states, so the contractors would basically need to choose only the contractors which are providing minimum working conditions. They didn't choose that option in the end. So the Posted Workers Directive from 2018 in the end said that everything that is in the Enforcement Directive is enough. It's not really true, because it can be seen also from the report from April this year, in which even the Council said that there are still challenges in which they are still dealing with challenges of posted workers in subcontracting chains, including long subcontracting chains that you can just track. It's very hard to track the subcontracting chains which have a lot of subjects in. And in that case, we can't track how are the posted workers actually treated at the end of the chain. And there is also a lack of transparency, but the lack of accountability of contractors. So basically, the liability that is provided in the Enforcement Directive is not enough, and the Council said it by itself. But still, the irony of the whole report is that they said that only 10 member states have introduced the full chain liability, and that only 4 member states have introduced further measures, which means that they are emphasizing that the measures that were provided by the member states are not enough. But what is the whole conclusion of the report? They said that the Commission could provide the guidelines on the applying more stringent rules on the national level, which means that they said that basically they don't see the point of getting new rules in the Posted Workers Directive. So they said that basically everything that is now currently in the Enforcement Directive from 2014 regarding the protection of posted workers in subcontracting chains is enough, even though that they are claiming that there are a lot of challenges and that posted workers are still considered as precarious workers in the subcontracting chains. So the conclusion of the report is we have a problem, but we are not going to solve it. It's questionable if the Commission actually figured out what is the main challenge and what is the main problem of the exploitation of posted workers in subcontracting chains. So when we are talking about the other possible mechanism of preventing the exploitation, we are talking about the human rights due diligence. So the Enforcement Directive from 2014 already has the provision that is mentioning the due diligence that is called the due diligence escape clause. That clause means that if some contractor would do the due diligence, he can be considered liable, which means that one is excluding the other. So the due diligence, if the contractor does the due diligence, then in any case, he can be considered liable for the exploitation of posted workers in the end of the chain. should it function like that? No, it should function in the symbiosis. Germany, as I already said, Germany introduced the obligatory liability, chain liability, and obligatory due diligence, and they are not excluding each other, which means that the posted workers are protected on the highest point. And a lot of trade unions, a lot of scholars claim that that is the best option, and I completely agree with it. And the human rights due diligence as such was starting to be introduced a long time ago already with the United Nations, but that was basically not applied because every third contract, every third company actually used the UN guiding principles on business and human rights. It was functionable. It was it considered to be a good introduction into due diligence. But since 2020, we can say that the EU actually started to introduce a proper way of due diligence in the scope of the subcontracting chains. Colleague Panev is going to talk about the directive a little bit more, so I'm not going to go into the details of that directive. I'm just going to say that in the scope of the Posted Workers Directive, how would it function? Since the directive on corporate sustainability due diligence, that is quite a new directive, is not talking about posted workers, so it's not explicitly mentioning the protection of posted workers. So it's still a question if it's going to actually protect posted workers or not. That is going to be the topic of my further research. But we can still see that that directive on corporate sustainability due diligence is a step toward a better protection of workers within the subcontracting chains. But the question is if posted workers are actually going to be covered with it or not. And I would finish with this, and I would be open for all the questions and all the explanations. But I won't take the whole floor for the corporate sustainability due diligence from colleague Panev. So I'm going to stop with this. Thank you very much.
Thank you.